Did you know there isn't actually a physical building called the Small Claims Court? Here is how the county court system really works in England and Wales, and what it means for your claim.
First, it is worth clarifying that there isn't a physical building called the Small Claims Court. In England and Wales, small claims are lower value disputes, usually up to £10,000, handled within the small claims track of the county court. The system is designed to be swift, proportionate, and far less formal than higher value cases. The biggest difference comes down to legal costs. In standard litigation, the loser usually pays the winner's legal fees. In the small claims track, you generally cannot recover solicitors' costs, even if you win. Apart from fixed court fees, each side pays their own way, which is why most people represent themselves.
Once a claim and defence are filed, the court issues directions. These are simple deadlines setting out when you must send your evidence and witness statements to both the court and the other side. Pay close attention here. Witness statements must include a statement of truth. Signing something you know to be false is contempt of court. Before reaching a trial, the court offers a free small claims mediation service. A mediator doesn't take sides, but they can help you negotiate a settlement out of court. If you do end up at trial, expect a short, informal hearing lasting a couple of hours, where thorough preparation is key.
Don't let court deadlines or paperwork overwhelm you. Head over to Small Claims Court Genie to grab our ultimate guide and get your claim fully prepared today.